Let me just start. Smadar's paper presents two separate but related arguments. And the first one is, perhaps I'm even stating it a little more categorically than Smadar said it, is that the recourse to Israeli law in the military courts is illegal because it exceeds the limits of permissible action under the Hague Law and the Geneva Convention. And the second argument is that as a matter of policy, the recourse to Israeli law contributes to the inequality of arms, which is already inherent in the military legal system because Israeli law is more accessible and more familiar to the prosecution than it is to the defense. And I'd like to comment on both arguments. Let me start with the bottom line, that I'm not fully convinced by the first argument. I do subscribe to the second one, which I'd also like to take a step further to put in the slightly wider framework. So let me start with the first argument. And I think at the outset it should be said that it's clear that Israeli law has not been extended extraterritorially to the West Bank. What we're talking about is the assimilation of the criminal procedure in the military courts to the relevant law that applies under Israeli law. Now, there's no doubt that assimilating the law of the occupied territory to that of the occupant for the sake of assimilation is impermissible. But the question is whether the duplication of Israeli law is in fact done for that reason. The Geneva Convention allows the occupant to change the penal law in the territory where that is necessary to enable it to fulfill its obligations, to maintain the orderly government of the territory, and to ensure its own security. And on this basis, Israel set up the military court system, which enforces military law. So the Security Provisions Order, the SPO, was not modeled on Israeli law at the time, which is part of the reason why it was so draconian. But the SPO was enacted 40 years ago. And human rights standards have developed since then. And arguably, Israel has to update the SPO, otherwise it would be found in violation of a human rights law. Now, if the occupant identifies a body of law which it believes to be to correspond with human rights standard and is worthy of emulating, I think that it would be a bit odd if it was precluded from referring to that body of law simply because it was its own law. So I would argue that assimilation of the law to Israeli law is not impermissible as such, but it does raise serious problems because of the inaccessibility of this law to the defense, for example, and because, more significantly, because of Smadar's second argument, to which I fully subscribe, and that is that the reliance on Israeli law exacerbates an already existent bias in the military courts in favor of the prosecution. Now, let me clarify. I'm not arguing against the integrity of the judges. What I have a problem with is the integrity of the system. A court system where the prosecutor and the judge come from the same constituency while the defense belongs to a different constituency is flawed. And I don't think there's any way of removing the problem altogether. The constellation ought to have been, I mean, when the Geneva Convention, which allowed this, was formulated, was that occupation was expected to be short-lasting. And then, you know, and it's also a question of what the alternative is. A flawed course is obviously better than a flawed court is obviously better than no court at all. And here we come to little is better than nothing. And in fact, in 2006 and 2007, some Israeli law professors have submitted amicus curiae briefs to the Supreme Court of the United States, advocating that. Well, by basically hailing the judicial system, the judicial review system in Israel, including in the West Bank, as a system worthy of emulating. But that was said in the context of what was then American law. Of the alternative was to hold suspected terrorists indefinitely and incommunicado. So if these are the options, nothing or something, then obviously something is better than nothing. But this is only acceptable on the short term. If we're talking about a 45 years old occupation, and I don't know how exactly you calculated, but this week we're celebrating 45 years, or at least marking 45 years, I don't think that a little can be a satisfactory option. And moreover, if the military legislator can modify the SPO so drastically, to civilianize it so drastically, it might raise a question as to the justification of military law altogether. Now, I'm not seriously advocating the closure of the military courts. I think they're necessary for adjudicating offenses against the security of Israeli forces, although there's alternatives to that as well. But the jurisdiction of these courts goes beyond, way beyond security offenses. According to the reports of the military advocate general, security offenses, and that includes security against the defense of the state, and something else. I forget the acronyms at this moment. They make up no more than half of the indictments. There's also criminal law, that just regular criminal law, and traffic offenses. Why do traffic offenses have to be adjudicated in military courts under military procedure? And my third comment, which is a long one, is about Smadar's point about the illusion that applying Israeli law offers better guarantees of human rights of the defendants. And I want to take that one step further and focus on one of the arguments that have been put forward for incorporating Israeli law, and that is equality, which I think Smadar supports, and this is where I beg to differ from her. Now, Smadar cites Shaul Goldon, the previous president of the Court of Appeals, who argues that this incorporation promotes equality between persons put on trial in Israel and those put on trial in the West Bank. And he notes that the same affairs may come before courts in Israel and in the West Bank simultaneously, and therefore the same law should apply in both to the extent possible. And I'd like to challenge the relevance of equality at two levels. The first one is the tendency to use equality as a panacea. Now, we extol equality because different treatment to equal people is an infringement of human dignity. But equal treatment to different people is equally an infringement on human dignity. Different people are entitled to different treatment. And Palestinians put on trial before military courts in the West Bank are not in the same position. They're already in an inferior position to Israelis being put on trial in civilian courts in Israel, or Palestinians being put on trial in civilian courts in Israel. The risks to defendants in a democratic regime are different to the risks to defendants in a regime of occupation. There's no reason to assume that the same system should apply in both. And the law of occupation doesn't deal with equality. It deals with ensuring minimum standards to defendants or to the population at large. So, for example, if the shorter period of detention under Israeli law is appropriate also for defendants Palestinian defendants in the military courts, it should be duplicated, but not for the sake of equality, but simply because it's less injurious. So equality would be part of an argument that says, if this is good enough in Israel, it ought to be good enough in the West Bank, which, in fact, I don't find a convincing argument. I don't think equality plays in either direction here. But more than that, I want to warn against the illusion that equality in the applicable law ensures substantive equality. And at the risk of some self-promotion, I'll say that this is something I've been looking at with Amir Paz-Fuchs, who's a senior lecturer here at ONO, in the context of labor law. In 2007, the Israeli Supreme Court ruled that Israeli law applied to the employment of Palestinians working in the Israeli settlements. And it said that this conclusion was in line with the principle of equality between Palestinians and Israelis working in the settlements, and between Palestinians working in the settlements and Palestinians working in Israel, which is exactly the same argument as with the defendants. And I think that whether we're talking about criminal law or labor law, the intentions of the courts are admirable. But I think there's a blind spot here, and that's the manner in which the law is applied, because equal law does not ensure equal treatment. Ask 50%, 52% of the population of the world. I'm talking about women. And I think uniformity in the law is neither sufficient nor even necessary to ensure substantive equality, because judges can reach substantively similar results under different legal systems. For example, if the maximum period of imprisonment under the law in the military courts is much higher than that applies in Israel, judges can still impose a sentence of no more than 20 years, which is the law in Israel in the relevant offenses, on a Palestinian defendant in the military court. They don't have to go to the maximum, except maybe in extreme cases. So the problem is not the applicable law. That's not the obstacle. Bottom line, I think Smadar's article points to an intractable problem that cannot be resolved through technical means because it's a systemic problem. Translating Israeli law and even jurisprudence into Arabic would not put the defense on par with the prosecution, because the problem is much more profound. It's an imbalanced system. And Shaul Goldon's words are revealing. I want to quote something, and please note what he does not say. This is translated from Hebrew. The recourse to Israeli law is inevitable. First, all those involved, whether in legislation or in adjudication, grew and were trained in the Israeli system. It's only natural that they turn to the legal sources familiar to them. Now, note that he says, all those involved, whether in legislation or in adjudication. He doesn't mention the prosecution. He doesn't mention the defense. And I think this is part, or this is a reflection of a more general approach, according to which the courts often regard themselves as the guardians of the defendants and of their interests. Another manifestation is the call of the courts on the legislator to modify the law with the express intention of providing better protective measures for defendants. And I think courts have an important role in guaranteeing the maintenance of due process and human rights, but they can't hijack the role of the parties, especially not that of the defense. And it's particularly an acute problem when the court is not neutral. So what we have is a system that marginalizes the defense, which is already at a disadvantage. I think it's another instance of the self-declared very benevolent occupant not looking itself very squarely in the mirror. Thank you.